My brother signed my name to a fraudulent contract, and our parents told me to confess before the board meeting. But they forgot one tiny detail. The fluorescent lights in the Hargrove and Sons conference room buzzed like trapped insects. I remember staring at them while my father explained, in his carefully modulated boardroom voice, exactly how the rest of my life was going to go. Outside the floor-to-ceiling windows, downtown Charlotte glittered like it had no idea what was happening 22 floors up. It probably didn't. Bad things tend to happen in well-lit rooms while the rest of the world looks the other way. Let me back up. My name is Claire. I'm 28 years old, and for the past 3 years I had been the lead contract specialist at Hargrove and Sons, a mid-size commercial real estate firm founded by my grandfather and now run by my father, Douglas Hargrove. I had worked my way into that role the hard way. 2 internships, a paralegal certification I paid for myself, and 4 years of doing the work that nobody else wanted to do. Cross-referencing zoning permits, catching liability clauses that would have cost the firm 6 figures in litigation, flagging a vendor agreement that turned out to be a shell company funneling fees to a competitor. I was good at my job. I knew every document that passed through that office, every signature, every revision timestamp. My brother Weston had been handed his VP title on the day he turned 25. That is not bitterness. That is a fact, and it matters to understand what came next. Weston was 2 years younger than me, 6 inches taller, and had the kind of effortless confidence that only comes from never once being told no. He played golf with my father every Sunday. He wore the right suits and said the right things at client dinners and laughed at the right moments. What he did not do was read contracts. What he did not do was understand that a handshake and a verbal agreement are not the same thing as a legally binding document. What he did was forge my signature. The Dalton Group deal had been on the table for 8 months. It was the biggest acquisition the firm had ever attempted, a portfolio of 6 commercial properties in the Research Triangle worth approximately $42 million. I had been assigned to review the final purchase agreement before it went to signature. I had flagged 3 issues. A financing contingency that was worded in a way that could trap the firm in a deal even if the bank pulled funding, an environmental inspection clause that was missing entirely, and a discrepancy in the square footage on 2 of the properties that could affect the appraisal. I sent my memo to my father on a Tuesday. I copied Weston because he was technically the lead on the client relationship. I clearly marked the document not for signature pending revisions. On Thursday, the signed purchase agreement landed on the Dalton Group's attorney's desk. Signed by me. My name. In my handwriting or something close enough that a casual look would not catch the difference. Weston had practiced it. I found that out later. He had been practicing my signature on scratch paper for 2 weeks, which tells you something about the kind of person he is, and also about how long he had been planning this. The Dalton Group's attorney caught the financing contingency issue within 48 hours and sent a formal notice of dispute. That notice landed on my father's desk on a Friday afternoon, and by Monday morning, the 3 of us were in the conference room with the door closed. I walked in thinking I was there to help fix the problem. I had my original memo pulled up on my laptop. I had the metadata showing exactly when I had created the document, exactly when I had sent it, exactly what revisions I had flagged. I set my laptop on the table, and I looked at my father and I said, "I've already pulled the documentation. I never signed that agreement." My father looked at me for a long moment. Then he looked at Weston. Weston looked at his phone. "Claire," my father said, in that voice, the low, careful voice he used when he had already decided something and was simply waiting for you to catch up. "The signature on that document matches yours. Our notary witnessed it. Your notary is Marcus Chen, who has been with the firm for 11 years and would not lose his job for anything," I said. Did he actually watch the signing? Or did he notarize after the fact because Weston asked him to? Silence. My father folded his hands on the table. "The Dalton Group is threatening to pull the deal entirely and pursue damages," he said. "If this goes to litigation, the firm's reputation is finished. We are talking about 40 years of my father's name being dragged through discovery proceedings and depositions." "Then we tell the truth," I said. "We tell them there was an unauthorized signature, we offer to renegotiate with the corrected terms I already flagged, and we find out exactly who signed that document." Weston put his phone face down on the table. He looked up at me then, and his expression was something I had never seen on his face before. Not guilt, not apology, calculation. He looked the way he looked when he was deciding which club to use. The simplest solution, my father said, as if he were discussing a zoning variance and not my entire professional future, is that you made an error in judgment. You were under pressure. You signed the agreement before your revisions were complete. It was a mistake, and you take responsibility for it. I stared at him. You want me to say I made the error? You are the contract specialist, my father said. It is within your scope. You sign documents regularly. A moment of poor judgment under deadline pressure is believable and defensible. We negotiate a settlement with Dalton, the firm absorbs the cost, and everyone moves on. And Weston moves on, I said. My father did not answer that. He is 6 months away from being named managing director, my mother said. I had not even noticed her in the corner of the room. She was standing near the credenza, holding a coffee cup she had not touched, wearing the expression she reserved for situations she had already decided were beneath discussion. The board votes in November. A scandal of this nature, tied to him specifically, would derail everything we have worked toward. Everything you have worked toward, I said quietly. Do not be dramatic, she said. You are a contract specialist. You are replaceable, Claire. Weston is being positioned to lead this firm into its next decade. That is not a small thing. There it was. Said out loud, in a room, to my face, replaceable. I looked at Weston. He was examining a spot on the table. If you cooperate, my father continued, we will cover any professional liability. Your position here is secure. We will give you a title change, a raise. This does not have to affect you significantly. It would affect my professional license, I said. It would affect my reputation. If Dalton pursues this and my name is on that contract, I could be barred from working in contract law anywhere in this state. We have attorneys who can manage the exposure, he said. Your attorneys, I said, who work for the firm, who work for you. My father looked at me the way he used to look at me when I was 12, and asking why I couldn't also be in the accelerated soccer program like Weston, patient, slightly tired, as if the question itself revealed a fundamental misunderstanding of how the world worked. This is the decision that needs to be made before the Dalton Group's attorney contacts our outside counsel on Wednesday, he said. I suggest you spend some time thinking about what is most important to you. He stood up. Weston stood up. My mother set down her untouched coffee. They left me in the conference room. The Charlotte skyline glittered through the glass. I sat there for a long time. Here is what I want you to understand about why I almost said yes. It wasn't the money. It wasn't even the job. I had been in that family for 28 years, and some part of me, some stubborn, embarrassing part that I am not proud of, still believed that if I just did the right thing, if I just absorbed this one more thing, my father would look at me differently, would see what I had actually given this firm, would finally stop looking through me to the sun standing behind me. That is the part they were counting on. They knew it worked. It had always worked. I took the elevator down to the parking garage. I sat in my car, and then I did something I almost never do. I called my best friend, Priya, who is an employment attorney in Raleigh and who has exactly zero patience for nonsense of any kind. I told her everything in approximately 9 minutes. When I finished, there was a silence that felt surgical. Tell me you did not agree to anything, she said. I didn't agree to anything. Good. Now listen to me very carefully. Do not touch anything in that office. Do not send any emails from your work account. Do not delete anything. Do you have personal copies of your original memo and the transmission records? My memo was sent from my work email, I said. But I stopped. Something moved at the back of my mind. A small, specific thing. Priya, I also sent a copy to my personal email, because I was going to work on the revisions over the weekend, and I needed access from home. When? Tuesday morning. Before I sent the official version. It was a draft, but it's time-stamped. That timestamp, Priya said, and her voice changed, became very precise, puts your revision memo in existence before the signature on that contract. If the signing happened Thursday, the signature is dated Thursday afternoon, I said. My memo flagging the issues was sent Tuesday at 8:47 the morning. The silence again. Then, Claire. There is a metadata trail on every document your firm uses. Every revision, every access, every time a file is opened or modified. Your firm uses DocuSign for official contracts, correct? For external contracts, yes. Internal review documents are just shared on the server. Okay, here is what I need you to do. Priya walked me through it. She told me to forward my personal email chain to a secure account she set up for me. She told me to write out a detailed, time-stamped account of every conversation I had just had in that conference room, with every word I could remember, and send it to that same secure account. She told me to take screenshots of my sent folder before I logged out of my work email for the day. And she told me to think hard about whether there was anything else, any record, any communication, any document that existed independently of the firm's controlled server. I sat in the parking garage and I thought, the Dalton Group file. I had kept a physical copy of my revision memo in my desk drawer because I am someone who keeps physical copies, a habit that my coworkers found old-fashioned and that my father had specifically told me was unnecessary in the digital age. I had printed it on the Tuesday afternoon after I sent the email because I had intended to bring it to the weekly review meeting on Wednesday, which my father had canceled at the last minute. The print metadata on our office printer logs every job: time, user, document name. Our printer logs were stored locally on the office server, but they were also backed up automatically to a third-party archiving service the firm used for compliance purposes, a requirement of our real estate licensing. The archiving service was not managed by the firm. It was managed by an independent company in Atlanta. I had not printed a fraudulent contract. I had printed a revision memo from my login on Tuesday afternoon with the document title Dalton, Revisions, Pending, CMH, my initials. My father did not know about the archiving service. He had outsourced the compliance infrastructure set up 3 years ago and had never engaged with the details. Weston absolutely did not know about it, because Weston did not read operational emails. My hands had stopped shaking. I went back upstairs. I smiled at the receptionist. I went to my office and I printed one additional document, a full activity log of every action on the Dalton file from my credentials, and I folded it and put it in my jacket pocket. I took my personal planner from my desk drawer. I took the physical copy of my revision memo. I took my certified paralegal credential, which was framed on the wall, and I put it in my tote bag because something told me I would not be coming back for it later. I sent one email from my personal account to the Dalton Group's lead attorney, a woman named Sandra Park, whose contact information was on every piece of correspondence I had processed for 8 months. The subject line was, "Regarding the Hargrove signature dispute, independent evidence available." I kept the body of the email to 4 sentences. I told her I was the contract specialist whose name appeared on the disputed agreement. I told her I had documentation establishing that I had flagged unresolved issues with that agreement prior to the signature date. I told her the signature was not mine. I told her I was available to speak with her or her client's representatives at their earliest convenience. I hit send. I logged out of everything. I picked up my tote bag, and I walked out of Hargrove & Sons for what turned out to be the last time. My father called me 40 minutes later. I let it go to voicemail. My mother called twice. Voicemail. Weston texted, "You're making this so much worse for yourself." I took a screenshot and sent it to Priya. Priya had already reached out to a colleague who specialized in professional fraud and licensing disputes. By 9 o'clock that evening, I had signed a representation agreement. By the following morning, we had filed a formal complaint with the State Real Estate Licensing Board, attaching my time-stamped revision memo, the email chain, and a formal records request directed to the third-party archiving service for the printer log. The archiving company responded within 24 hours. Compliance firms tend to be efficient when there is a potential fraud matter involved. It protects them too. The printer log showed my document, my credentials, Tuesday 2:14 p.m. The DocuSign audit trail on the Dalton purchase agreement, which the firm had used for the final execution version, because the Dalton Group required, it showed that the signing session had been initiated from a company laptop, specifically, from the laptop assigned to Weston Hargrove, VP of Client Relations. The IP address was registered to the office network. The time was Thursday, 3:47 p.m. No one had logged in as me. Someone had simply typed my name into the signature field and had Marcus Chen, the notary, witness a printed copy afterward. DocuSign had the original session data. DocuSign does not lie. The board meeting was on a Wednesday. I know this because Priya received a call from the firm's outside counsel on Tuesday afternoon, trying to arrange an emergency mediation before the board convened. The call was an attempt to get me to accept a confidentiality agreement and a settlement in exchange for signing an amended account of events. The settlement number they offered was significant. The confidentiality terms were airtight. Priya told them we would see them Wednesday. I had not spoken to my father. I had not spoken to my mother. I had received a total of 23 calls and 11 texts between the two of them, ranging from conciliatory to threatening to, in one memorable case, my mother describing my actions as a betrayal of the family that my grandfather had built. I want to be clear that I felt every single one of those messages. I am not made of stone. These were my parents. The firm had my grandfather's name on it. I had grown up in the hallways of that building on bring your child to work days, spinning in the desk chairs, eating vending machine crackers, believing that one day I would do something there that mattered. I had done something that mattered. It just wasn't what any of us expected. The Dalton Group's attorney, Sandra Park, turned out to be someone who did not appreciate having her client's $42 million transaction complicated by internal family fraud. When our evidence package reached her, she forwarded it to the board's independent legal counsel within 3 hours. The board meeting was not what my father had planned. I walked into that room, the same conference room, the same buzzing fluorescent lights, and this time I had Priya beside me. And across the table were 4 members of the Hargrove and Sons board, the firm's outside counsel, Sandra Park representing Dalton's interests, and the independent legal counsel the board had retained to assess the situation. My father sat at the head of the table. My mother was not present. Weston was not present. I found out later that outside counsel had advised against it. My father looked at me when I came in. I cannot fully describe the expression on his face. It was not anger, exactly. It was something more like the look of a man watching a controlled demolition he thought he had planned and realizing, too late, that he had miscalculated the charge. Sandra Park presented the evidence first. The DocuSign session data, the IP records, the printer log from the archiving service. My revision memo, time-stamped Tuesday, the text message from Weston, which was a personal communication on a personal device, admissible for purposes of establishing context. Priya presented the formal complaint already filed with the licensing board, and noted that a concurrent complaint had been filed with the State Bar regarding Marcus Chen's notarization conduct. One of the board members, a woman named Patricia Ellsworth, who had been with the firm since my grandfather's era, asked my father a single direct question. Douglas, did you know the signature was not Claire's when you asked her to take responsibility for it? The room was quiet in a way. I had never heard a room be quiet before. My father said, Patricia, I think we need to allow counsel to— I am asking you a direct question, she said. Did you know? He did not answer. Which was, of course, an answer. What happened after that took several weeks to fully resolve. But I will give you the version that matters. The Dalton Group withdrew the original purchase agreement entirely, as was their right, and chose to re-engage with a renegotiated version of the contract, the corrected version, based on my original revision memo, executed through a third-party broker rather than Hargrove and Sons directly. The firm lost the deal. The firm also lost 3 other clients who learned of the matter through industry contacts, because real estate is a relationship business, and word travels. The licensing board opened a formal investigation into the fraudulent signature. Weston voluntarily resigned from his VP position 48 hours before the board voted to terminate him. The vote was 4-1. My father was the one. Marcus Chen surrendered his notary commission as part of a negotiated arrangement that kept criminal charges off the table. He had a family and had made a terrible decision under pressure from a boss he had spent 11 years trying not to disappoint. I am not without sympathy for that. I understand it better than I wish I did. My father was removed from his managing director role by majority board vote. He retained his equity in the firm, but operational control passed to Patricia Ellsworth on an interim basis, pending a search for new leadership. On the day the board vote was finalized, I received a call from a number I didn't recognize. It turned out to be my grandmother's estate attorney, a quiet man named Harold Fisk, who had drafted my grandfather's original partnership documents, and who had remained connected to the family in a formal, arm's-length way for decades. He told me that my grandfather, who had passed away 6 years ago, had included a provision in his personal estate separate from the firm's partnership structure that directed a sum of money to any direct descendant who could demonstrate professional achievement independent of family business. The provision had sat dormant because the conditions had never been formally assessed. Harold Fisk had been watching the licensing board filings. He told me that, in his opinion, and in the opinion of the estate's independent trustee, my conduct throughout the matter, the documentation, the formal complaint, the refusal to accept a fraudulent narrative constituted exactly the kind of independent professional integrity my grandfather had intended to recognize and reward. The amount was $380,000. I sat in my car in a parking lot in Charlotte, and I read that email 4 times. Then I called Priya. Then I cried, which I had not done once through the entire preceding 3 weeks, and which I am not embarrassed about. My father has not called me since the board vote. My mother sent one email, brief and formal, that said she hoped I understood the gravity of what the family had lost. I read it once and did not reply. Weston texted me 2 weeks later, at 11 p.m. on a Saturday. 1 word. Seriously? I did not reply to that either. I am not going to tell you that I feel nothing about any of it. The truth is more complicated than that, and I think you already know it is. You do not spend 28 years being someone's daughter, someone's sister, and then feel nothing when the architecture collapses. You feel it. You feel it in the morning when you reach for your phone and see no messages. You feel it at the grocery store when you walk past the brand of crackers you used to eat in your father's office as a little girl. Grief is not always about people who were good to you. Sometimes it is about the people you needed to be good to you, and the long project of accepting that they weren't. But here is also the truth. I sleep at night. I sleep the way I have not slept in years, without the low-grade vigilance of someone who has spent too long braced for the next thing, the next comparison, the next reminder that her value is always conditional on someone else's convenience. I took the $380,000. I enrolled in a 12-month contract law certification program at a university in Boston. I found an apartment in a neighborhood where nobody knows my last name or what it used to mean. I am building something that is entirely mine, with my credentials, in my handwriting, which is, as anyone who reviews the documentation will confirm, distinct from my brother's version of it. My grandfather, it turns out, knew the difference. I think about him sometimes, that steady, precise man who built a firm from scratch and then quietly wrote a provision into his estate for a grandchild who hadn't yet done anything worth recognizing. He must have seen something. He must have decided, long before any of this happened, that independence was worth rewarding, that integrity was worth leaving money for, even if no one ever ended up claiming it. I claimed it. I am still claiming it, one careful decision at a time. And for the first time in a life that was largely spent on the wrong side of other people's calculations, I am the one who knows what the documents say. I am the one who kept the copies, and I am the one holding the pen.